Hi, everyone. Thanks for joining. My name is Joe Goldman. I'm one of the new co-chairs of the Trust and Estate section, and I want to welcome everyone to the program, which I'm very excited about. This program is Estate Planning with Charitable Trust, presented by Paul Frimmer. And with Paul here as a resource, I imagine there will be a number of questions. So if you do have a question, please go ahead and enter it in the Q&A box, and Paul will get to as many as he can at the end of the program. So before we begin, a couple of housekeeping announcements. You'll receive your MCLE certificate shortly after the program. Please take a moment to complete the survey that's included with your certificate. Also, program materials should have been emailed to you already, but we'll also include a link to the program materials in the chat box. Next up, we have a few words from our sponsors. So first, I would like to introduce Nancy Sanborn and Brian Joy of the Sanborn team.
Hi, everyone. I guess this seems apropos, along with discussion on charitable trust, to let everyone know that normally this time of the year we have been doing drawings for food banks, and someone from the crowd has picked the food bank. This year we have joined with the Beverly Hills Bar Association and the Association Barristers to support their drive to support a nonprofit that serves family in South LA with particular focus on sex trafficking victims and young people. So we are doing a matching donation of up to $500 for anything that people from this section decide, or any section decide to donate. So the information is in the chat box. I hope you participate. And we're kind of excited to be able to do that. And I want to wish everyone a happy Thanksgiving and a good holiday, and we'll see everyone in January.
Happy Thanksgiving, everybody. Have a good meeting.
Back to you, Joe.
All right. Thanks, Nancy and Brian. Always appreciate your support. In addition to the Sanborn team, we're proud to have Orit Gadish of Geffen Real Estate as a sponsor. Geffen Real Estate specializes in representing trustees, administrators, and executors in the sale of residential and commercial real estate. Orit and her team renovate properties strategically with payment made through escrow to allow for their clients to maximize the return of each sale. Geffen Real Estate sells properties throughout the state of California and is currently working on properties as far north as San Leandro and as far south as San Clemente and Menifee. Orit is an author for the CEB and is also the author of The Practitioner's Handbook for Probate Real Estate, which is available on Amazon. The link to the book is in the chat box, and if you're interested in reading it and providing a review, text Orit and she'll send you a complimentary copy. The Trust and Estate section is also sponsored by Glen Oaks Escrow. Marcine Klein is a full-service escrow officer specializing in probate, trust sales, conservatorship, and both court and independent administration of Estate Act transactions. On a daily basis, Marcine works to ensure that even the most challenging escrows close smoothly and that our clients are beyond happy with their experience at Glen Oaks Escrow. Next up is California Title Company. California Title Company provides comprehensive and timely title insurance protection for home buyers, including first-time home buyers, sellers, veterans, and military personnel, seniors, real estate agents and brokers, mortgage lenders, and commercial real estate professionals. Last but certainly not least is Manufacturers Bank. Simplify your banking, let Manufacturers Bank do it for you. Manufacturers Bank has a dedicated trust and estate banking team with the experience to handle all of your banking needs. Contact Brian Flores, the Vice President and Senior Relationship Manager there, for more information. All right, next up, I will hand it over to Courtney Cole for legal updates.
Thank you, Joe. Today I'll be covering Day v. Traver, Court of Appeal, case number B305834, 2nd District, filed September 27, 2021. In this case, beneficiary Ian Day filed a petition challenging the trustee's conduct, including investment decisions that he was empowered to make under the terms of the trust. As a result, the trustee later filed his own petition, seeking an order that Day's petition constituted a contest in violation of the trust no contest clauses. Day responded with a motion to strike the trustee's petition as an anti-SLAPP violation. The probate court denied his motion, finding that under the minimal merit standard applicable to anti-SLAPP motions, it was at least possibly conceivable that the trustee's action was within his discretion, and as such, Day's petition could constitute a contest. Day appealed the denial of his motion. The Court of Appeal affirmed the probate court's decision. As outlined by the Court of Appeal, in order to succeed on his motion to strike, Day would have to show that the trustee's petition did not have minimal merit. In analyzing this issue, the Court of Appeal found that the trustee's petition had satisfied the minimal merit threshold because Day's petition sought to limit the discretion of the trustee by challenging his use of trust assets to purchase life insurance and to fund other trusts with the proceeds. The Court of Appeal noted that a challenge to investment decisions that a trust expressly empowers the trustee to make can amount to a contest. The Court of Appeal also rejected Day's later attempts to narrow the scope of his challenge, noting that he could not avoid the consequences of his broad challenge to the trustee's discretion by belatedly narrowing the focus only to the specific conduct that directly resulted in his loss of a beneficiary interest. As explained by the Court of Appeal, the purpose of no contest clauses is to discourage litigation that challenges the intent of the donor. A pleading that initiates such litigation can violate a no contest clause, even if its allegations are later withdrawn. Importantly, however, the Court of Appeal limited its holding to the context of the anti-SLAPP motion and made no findings on how the probate court should ultimately rule on the trustee's petition. And with that, I will turn it to Dina, who will introduce our speaker.
Hi, thanks, Courtney. Good afternoon, everyone. I'm Dina, and I'm one of the program co-chairs this year. Very pleased to announce Paul Frimmer as our speaker today. Really doesn't need much of an introduction, but just a few words. He is a partner here at Loeb & Loeb in Los Angeles. Really is a prolific speaker and writer on this area of estate planning and in particular charitable trusts. So really want to thank him for being here, and we look forward to having him speak. Paul?
Thank you, Dina. Thank you all for coming. This is a topic that many of you may not find appealing because it will not occur to you in your practices every day, but I think at least if you get some high-level information, you'll be able to serve your clients a little bit better. I am going to assume some knowledge in this area because if I was to go through all of the trust provisions that are necessary in remainder trusts and lead trusts, I would probably bore you to death, and I'd prefer to bore you with some high-level insights into these documents and how they're used. Before we even start talking about the trusts, the first thing we need to talk about is whether you should consider using a charitable remainder trust and whether it is possible to use a charitable remainder trust. This trust idea typically comes with a phone call that says something like, I'm an escrow to sell something, and someone said that if I put this asset in a charitable remainder trust, I can avoid paying income tax. And so the question is an assignment of income question. Is it too late for you to put the asset into the trust and avoid income tax? And the rule is, by revenue ruling, is that if the seller is obligated to sell on the date the property is given to charity or to a charitable remainder trust, then the capital gains is the seller's capital gain and not the charities or the trusts. So if you're an escrow and the last thing that needs to be done perhaps are ministerial, administrative things, then it may be too late and the seller may have the capital gains tax. If you're starting to think about selling the property, talking to brokers, maybe even getting a non-binding LOI, then perhaps you can put the property in the trust. But there is no fine line on what is appropriate and what is not. And several of the leading cases on this subject, which are in the outline, give a kind of a fuzzy line, even though the IRS has given a bright line that says if the seller is obligated to sell, then it's too late. So that's the first consideration. Is it too late? But assuming it isn't too late, I think the thing that most people overlook is the economics of a charitable remainder trust. These trusts are marketed by various people as being the greatest thing in the world because you can avoid or at least postpone capital gains tax on the sale of an asset. But I think you need to analyze the economics of the particular transaction before you go forward. I think some clients probably have a charitable inclination when they create these, but I think most people who are thinking about a charitable remainder trust have been told that this is better than selling the asset and paying the capital gains tax. And by better, they mean economically better. So you need to test to see whether that's true. And to analyze this, and by the way, most banks and investment advisors have programs that do this, but in a theoretical sense, the way you analyze this is by looking at the benefits and the burdens that the grantor of the trust gets by creating one. So the first benefit is the grantor gets a tax deduction. And the tax deduction isn't 100% of the property because the grantor has a reserved income interest. And so the deduction is based on the fair market value of the remainder interest. And depending on whether the ultimate charity is a public charity or a private foundation, that deduction may be for fair market value or basis. And that tax deduction generates cash. So let's take a simple example. We have a zero basis asset with a $1 million value, and it's being given at the end to a public charity. And let's suppose the grantor's charitable deduction is $500. In a 50% tax world, that $500 deduction is going to generate $250,000 of tax savings or cash for the grantor. If you take that cash and you project out the investment of that cash until the donor's expected time of death, that cash will grow in a taxable world. It will have dividend income, it will have capital gain, the asset will be turned over from time to time perhaps, and you can project out how big that asset is going to grow by the time life expectancy occurs. The second benefit that the grantor gets is that no capital gains tax is payable at the time of the sale because charitable remainder trusts are exempt from income tax. And so if you took that same asset of $1 million with zero basis and you sold it, you would have approximately $630,000 left in California because the capital gains rate is 37%. So the savings of $370,000 is also a benefit because that extra money is going to grow inside the trust on a tax-free basis because the trust doesn't pay tax. So you can take that $370 and project how long and how big it will get to life expectancy in a tax-free world of the CRT. So that 370 is now earning something for the grantor. So you add up those two columns at expectancy and you get a number. But at life expectancy, you lose the asset because it is payable to charity, or at least at death. But if you're looking at this, you need to look at life expectancy. So at death, the asset goes to charity and you've lost 100% of the asset. At the point where the sum of these two columns of assets, that the benefits from the trust, meet the detriment of losing the asset, you have reached a break-even point. And if the client lives longer than that break-even point, he or she will be economically ahead for having done this. If the client dies prior to that break-even point, the client would have been better off selling the asset and paying the capital gains tax. Now, there are tons of variables to make this determination. First of all, the capital gains rate has to be taken into account. The basis of the asset, because the higher the basis of the asset, the less savings there will be because there would have been less tax paid. Charity has to now have a 10% minimal interest in the trust. In the old days, charity could have a 0.000000001 interest, basically no interest, and the trust would be valid. But the service woke up to this and now insists on a 10% minimum. So that pushes out the break-even point because charity is actually going to get something. Whether you use a uni trust or an annuity trust makes a difference A uni trust is not intersensitive, so the deduction is pretty much the same no matter what the age of the grantor and the 75/20 rate. There's a slight difference for periodic payments, monthly, quarterly, etc. But in a charitable remainder annuity trust, the age of the grantor, the interest rate is very important. So you need to look at all of these things together to determine whether this trust has a possibility of being an economic win for this client. Now, some of you will say, well, my client doesn't have any children. He's going to give the property to charity anyway. Therefore, doesn't this make a lot of sense? Well, the analysis is the same for that client too. Even though the client doesn't have children, the client wants the maximum amount of assets during his or her lifetime. And therefore, you need to check the break-even point to see whether it's better to sell the asset, pay the tax, have the freedom to invest, in my example, $630,000 and do whatever you want with it, than to lock yourself into $1 million charitable remainder trust where you're limited to the percentage that can come out of the trust. So before you go into this, pay attention to the economics. They're really important. And as a general rule, for a single life, you have to be in your 70s before you have to be below age 65 or 70 before you can make money on this. It takes about 20 to 25 years to break even under most assumptions. So older people probably shouldn't be using this as an economic tool. Younger people can. In the ages of the dot-com people at age 40, the magic of compound interest has proven to be a windfall for these people, because these trusts at age 65 or 70 now are huge because of the inside buildup tax-free. So once you decide you're going forward to do this, you need to consider a couple of basic premises. We are all focused most often on what these trusts look like. And the IRS has published forms, so almost anybody can prepare a legitimate, valid charitable remainder trust on the face of it. And the forms are now annotated, so they give you choices, they give you some guidance as to what to do. Most charities have forms. It's easy to produce one of these things and make it look good. The problem is you also have to administer it properly. And people often don't focus on the administration of the trust. And there are many instances where the annuity or the unitrust amount was not paid out for a number of years. And the famous case now is Atkinson, in which the charitable remainder trust was disallowed because the person who created it never got a payment. Mrs. Atkinson was talked into creating a charitable remainder trust. She didn't need the money. She probably would have been better off just giving the property to charity right away. But instead, she created a trust, never took a payment. Trustee never paid her, presumably because she didn't ask, even though the trustee was required to do so. And the service disallowed the deduction, and the court agreed. So whenever you create one of these things, you not only have to make it look like a charitable remainder trust, you have to operate it like one. UBTI, unrelated business taxable income, has always been a problem for charitable remainder trusts until a few years ago. Having UBTI would disqualify the trust. And if those of you who are a little bit older will remember, whenever you were looking at a non-traditional investment in which there was a prospectus involved, the prospectus always has a provision that said, if you're putting this asset in a charitable remainder trust, please don't, because we generate UBTI. We can't help it. We use leverage, etc. The law was changed a while ago so that now a charitable remainder can have UBTI, but there is a steep penalty for having it. The rules now are that the trust pays income tax on the UBTI from principal. In addition, the UBTI enters what we call the tier system of taxation, and the result of which is you get UBTI taxed twice in most cases. And the tier system is a system for taxing the distributions from the trust. And in general, the tier system says that when you're making the distribution from the trust to the beneficiary, ordinary income comes out first. That's what you would expect from the IRS, because that's the highest taxed income. They don't want that income trapped in the trust and no tax paid. So ordinary income comes out first, not only current income, but accumulated ordinary income. And that's the first bucket, as we say. After you've paid out all of the ordinary income and all of the accumulated ordinary income, the next category of income that comes out is current capital gain and accumulated capital gain. And once you empty that bucket, the next category is other income, such as tax-exempt income. Again, tax-exempt income is kept in the trust so that more income tax is paid on the distributions from the trust. And then finally, if you get through the tax-exempt income, then you're paying out principal. But for most people in today's world, because you can't get a 5% ordinary return under a normal portfolio, if you're paying out 5% a year and you had an asset that was sold, then it is likely that 5% will include capital gain. So take my example of $1 million asset with a zero basis. The trust gets the asset, the trust sells the asset, has $1 million of capital gain, but the trust doesn't pay income tax. So that capital gain is put into the capital gain bucket. And let's suppose my grantor is entitled to 5% of the annual fair market value. So in year one, with a value of $1 million, the grantor is entitled to $50,000. But what did the trust earn that year? Well, even if the trust sold the asset on January 1st and put the assets in a portfolio of stocks and bonds, let's say, that portfolio might earn 2% under current economic conditions. But the grantor is getting 5%. So that 2% is ordinary income because the trust has 2% of ordinary income, interest and dividends. And the 3% will be capital gain because the trust has untaxed capital gain of $1 million. So when that $30,000 comes out of capital gain as capital gain to the grantor, now the capital gain bucket is reduced from $1 million to $970. And in a world in which ordinary income rates are relatively low, if you set your payout rate relatively high, then you're going to be getting a significant amount of capital gain every year. And in effect, you're turning this transaction into an installment sale. So to take a crazy example, let's suppose in my example that I sell for $1 million, I have $1 million of capital gain not taxed, and my payout rate is 10%. And the trustee invests in an S&P fund, and that fund pays 1% per year of ordinary income. I'm going to get $100,000 a year from this trust in year one at least. And of that, only 10% is going to be ordinary income. 90% is going to be capital gain. So of my $1 million of capital gain, my first year, 90,000 is coming out. And if you looked at this linear and you don't do the actual math, over 11 years, all of that capital gain is going to come out. And so rather than saving the income tax on that $1 million of capital gain, what I've done is I've turned this into an 11-year installment sale because I will ultimately pay the $1 million of capital gain. So when you're structuring these trusts and the temptation for the client is to say, give me the most I can get, you will find out that when you do the economic analysis, generally giving the client the least that the client can get is better because the less money that gets paid out to the client, and there's a minimum of 5%, the more money that can be accumulated tax deferred or tax-free inside the trust. And in a unit trust, which is what most people use, the client is getting 5% of the annual fair market value of the trust. Well, to the extent you can trap more income in the trust on a tax-free basis that is growing, 5% of a bigger number will happen every single year. And that's the magic of a charitable remainder trust is you are compounding income tax-free inside the trust, and the only leakage is the percentage that you get paid out. And so if you get paid out 5%, which is the minimum, and you can generate a much higher return inside the trust, compound interest will take over, and that 5% will be applied against an ever-increasing number. So contrary to popular opinion, it is usually better to use the 5% or a low payout rate than a high payout rate, especially if you're selling an appreciated asset in the trust, which is the typical approach for using charitable remainder trusts. Okay, so UBTI, be careful of it. You have some fiduciary issues too, because remember, the initial tax paid by the trust is chargeable against principal, and principal is what's ultimately going to the charities. So the charity may say to the trustee, why did you generate UBTI? Because you reduced the principal by doing so. So again, it's an economic analysis. If some investment is generating, 18 or 20%, and that investment is appropriate for a charitable remainder trust, it may pay to pay the capital gains tax and have a slight amount of double taxation because the charity is getting most of that income tax-free on a cumulative basis. So besides fiduciary liability and economics, UBTI is a dangerous asset to deal with. Let's talk about the types of trusts and the mindset when we create charitable remainder trusts. Remember, charitable remainder trusts were invented, so to speak, in 1969. Prior to 1969, you could create a trust that said income to my child, remainder to charity, and get a charitable deduction for the charitable piece. But people were abusing that, like people abused grits. So you set that trust up, you get a charitable deduction, and then you invest in assets that generate a huge amount of ordinary income or accounting income. So charity doesn't get the benefit of the remainder that it thought it got because your investment is not appreciating, its yield is being paid out to the income beneficiary. So viewing that as an abuse, Congress put this charitable remainder trust regime in place where we know now that absent some investment issues, charity will actually get the money for which the deduction was allowed. But in 1969, the typical investment portfolio for wealthy people, who are the people who use this, was a balanced portfolio of stocks and bonds. Many investments that we have today weren't even invented yet. Some of the derivatives that we use today, some of the investments that have weird names like DAX and SPACs and all those kinds of things weren't invented. And typically income in principle was governed by the income in principle law, and the fiduciary could balance the remainder versus the income beneficiary, and everybody was happy. But Congress realized that maybe people would be putting illiquid assets in these types of trusts, and they needed to have some type of format to deal with that. Because if you put, for my example, $1 million worth of land in this trust, and the land is not sold, and you need to pay out 5% in year one, you're going to have to pay out 5% of the land, which becomes awkward because there's discounting, and people will not get it right. So Congress decided, or somebody decided, that we'll create a special kind of a trust, which is affectionately called either a NIM-CRUT or a NI-CRUT. And NI stands for net income, and NIM stands for net income with makeup. And so these trusts pay out the lesser of the accounting income and the percentage. So the typical NIM-CRUT would say the grantor gets the lesser of 5% and the accounting income, interest, dividends, rents, not taxable income, accounting income. And so if you have an illiquid asset that isn't sold, like my land worth $1 million, in the first year, the grantor is not going to get anything because this land doesn't generate income. So accounting income is zero. Zero is less than 5% of the million. So the person gets zero. If you have a NIM-CRUT, net income with makeup, then the trust can make up the payments that were not made in the years in which the accounting income was not significant. So let's say in year 2 of my example, we sell the asset for $1 million. The grantor is owed, in quotes, $50,000 from the first year that he didn't get, and he's entitled to $50,000 for the second year. So the trustee can pay the grantor $100,000, but you need accounting income to do that. So for all practical purposes, the grantor will not get the makeup provision because under current investment rules or yields, the income will not be, the accounting income will not be 10%. So the grantor probably will just get his 5%. Now, these charitable remainder trusts have been sold by the insurance industry, and I apologize for the insurance people on the call, as wealth replacement trusts. Here is the idea. So you have an appreciating asset that you don't want to sell because you don't want to pay the capital gains tax. Maybe it's stock that you bought many, many years ago. So if you put it in a charitable remainder trust, you will be able to sell it tax-free. That capital gains will be working for you and you'll get 5% or whatever the percentage is. But the client says, but wait a second, you told me that when I die, charity gets this asset. That's correct. Well, that's not a good deal because I want to leave this asset to my children. So the insurance industry has a solution, as it does for just about everything. And that is, we'll take the distribution that you get, the 5%, and we'll use some of that to buy insurance on your life. And we'll put that insurance in an ILIT. And therefore, you'll get the best of both worlds. You'll get the 100% of the asset working for you inside the trust with no capital gains tax. You purchased a life insurance product that is not subject to estate tax because it's outside your estate in an ILIT. Your children will get the insurance proceeds free of estate tax. Charity will get something at the back end. Everybody wins. And so that sounds great, and sometimes it is great. But what has happened in the past, and there are several cases on this now, is that the asset didn't get sold in a timely manner. There was no cash flow from the trust with which to buy insurance, and the grantor died prematurely before the asset was sold and everybody had a chance to buy insurance. In the few cases that exist, everybody was liable. The charity was liable for setting this thing up. The insurance agent was liable. The advisor was liable. Everybody was liable because the plan didn't work as advertised, and the client wasn't told that the plan might not work as advertised. So you need to be careful in a wealth replacement trust. And theoretically, if you do the analysis that I mentioned at the beginning, you shouldn't have to replace the wealth, because if the client lives to life expectancy and the plan works as planned, you will have replaced the wealth by the two columns of assets that are growing. Now, in case the client dies prematurely, you could buy, in effect, decreasing term insurance for the term during which the client is replacing the wealth. And in theory, you could reduce the term insurance every year by the amount of wealth that's replaced. That's not practical, but you could reduce the term insurance every 5 years as the wealth grows in those two columns. So if you wanted to play the wealth replacement game, that's what you would do. You would buy term insurance through life expectancy, and then you would reduce it periodically as the wealth grows. What about the general diversification? Well, the trust has to have a provision that doesn't prohibit the trustee from realizing a reasonable amount of income or gain. So, for example, the trust says you must hold the ABC stock. The trust can recommend that the trustee hold the ABC stock, but it can't mandate it, or you will lose the benefits of a trust. So there are some cases in which the trustee was permitted to keep the stock. In these cases, it was a block of stock that needed to be kept together for control purposes, but the trustee followed the instructions and didn't diversify. Trustee was sued when the stock went down, and in two of the cases, at least in New York, the trustee lost. The trustee said, well, he wanted me to keep the stock, and he allowed me to keep the stock. The court said, having the allowance to keep the stock or permission to keep the stock doesn't overrule your fiduciary duty to see whether it was appropriate to keep the stock. So be careful when you're putting a concentrated position in the trust and you want that position to be held. Suppose you have encumbered assets. Can you contribute those to a charitable remainder trust? Well, you can, but it's really difficult, and I wouldn't even try. First of all, if your debt exceeds your basis, which is typical for many real estate investors, you will have gain on the contribution. And the purpose of creating this trust is to avoid gain. Secondly, if the debt is recourse, the trust becomes a grantor trust as to the grantor, and a grantor trust cannot qualify for a charitable remainder trust. So right away, you're dead. If there is a mortgage on the property and the charitable remainder trust pays the mortgage, that's self-dealing because the trust is relieving a grantor of some aspect of the debt, even if the debt is non-recourse. Charitable remainder trusts are subject to 4941. So basically, the rule should be don't contribute mortgaged property to a charitable remainder trust. What about tangible personal property? Let's say I have a Stradivarius, which is worth $5 million, and I inherited it from my grandfather when it was worth $100,000. So I have a huge gain in this Stradivarius, and I don't want to pay the capital gains tax. Because remember, the capital gains tax on tangible personal property is 28% federal, plus 3.8, plus 13.2 in California. It's 45%. So I have a huge incentive not to pay that 45% capital gains tax on basically $5 million. So I put the Stradivarius into a charitable remainder trust. First question, can I play it? No, that's self-dealing. The rule is that if tangible personal property is placed in a CRT, you cannot use the property. The only benefit the grantor can get out of the trust is the authorized payment. Use of the property is prohibited. It will disqualify the trust, and you'll be subject to the self-dealing penalties. So you can't use it, so you stick it in storage. You almost have to use a NICRUT or an IMCRUT because this Stradivarius is not generating income. And so you can't get your 5% if the property is not sold. So you put it in storage or you lend it to an orchestra to let somebody in the orchestra play it. People do that all the time with art. While the art is in the trust, it's lent to a museum till it's sold. So now you finally have a buyer for the Stradivarius and you sell it for $5 million, or the trust sells it for $5 million. What are the rules about deductions, etc.? Well, when I put the Stradivarius into the trust, I would normally expect to get a charitable deduction. Let's assume that at my age, the deduction is 50% of the value of the property put in. So do I get a $2.5 million charitable income tax deduction? Well, there are two rules that prevent you from getting the deduction at the time you create the trust. One is you don't get a deduction for a gift of tangible personal property to charity until all of the non-charitable interests have expired. And since I have an income interest in this trust and I'm a non-charity, there is still a non-charitable interest in this Stradivarius, me. So I don't get a deduction in the year that I create the trust. So now let's suppose I sell the property in the same year as which I create the trust, so I would get a deduction. Now the question is, what kind of deduction do I get? Well, tangible personal property to charity rules are specialized. If I give property, the use of which is concurrent with the charity's mission, then I get a fair market value deduction. If it's not, if I give a painting to a church auction, then I get a deduction limited to basis. So one might think if I'm putting a Stradivarius in the trust, maybe I better have an orchestra, the LA Philharmonic, as the remainder beneficiary, because I can argue that a Stradivarius is something that the LA Philharmonic will use, as opposed to giving it to my church or to LACMA, which is an art museum. Well, the problem is you don't get a deduction for fair market value because the rule is that on the date of the gift, it has to be relatively certain, and I'm paraphrasing, that the property will be used by the charity for the exempt function. And in fact, we know on day one that the Stradivarius is going to be sold because that's the plan. And in fact, it is sold as soon as possible after contribution. So the IRS takes the position that you don't get a fair market value deduction because it is not relatively certain that this Stradivarius will find its way to the LA Philharmonic. And in fact, it never does because it's always going to be sold. So your deduction is for basis, which in my case was $100,000 and 50% of basis because that's the charitable deduction. So I get a $50,000 charitable deduction. Now the question is, when do I get it? Well, normally when I create a CRT, I get the deduction in the year in which I put the property into the trust. But again, the rule for tangible personal property is you get the deduction when all of the unexpired interests or non-charitable interests expire. So if I put the Stradivarius in on December 28th and I sell it in January of the next year, I get the deduction the next year, not in the year I put it in the trust, because at that point, I, an individual, still have an interest in the trust. So now I get a deduction in January of the next year. What is my deduction? Well, we just went through an analysis that says when you put this property into the trust, you get a deduction for a percentage of basis. The IRS has said that in the one private letter ruling on point. I think most people who have looked at this disagree with the IRS, because at the time you get the deduction, the trust has cash. Remember, the Stradivarius was sold for $5 million. Once it's sold, I get a deduction. But at that point, the asset is not the Stradivarius, the asset is cash. So it seems to me, and most everybody who has looked at this, except the IRS, that at the point I get the deduction based upon the asset that's in the trust, which in this case is cash. Again, the private letter ruling on point says, no, you're still limited to the other rules. But I think the service is wrong. It's a private letter ruling. If you ever encounter this, I would take the deduction for cash at the time. Suppose you put a house in the trust that you're planning on selling. Can you live in the house? No, not for a nanosecond. Otherwise, you have self-dealing. I was shocked at a development person from a major university who planned a charitable remainder trust. And when I said, well, have they moved out of the house? He said, no, they're going to move when the house is sold. And I said, but didn't you put the house into the trust? He said, sure, but they can live there until they sell it. And the answer is they can't. So be really careful when you're putting a use asset in the trust. It will be self-dealing if you use it. Subchapter S corporation stock. Many years ago, the law was changed so that charities can hold subchapter S stock. The rules are somewhat draconian in terms of the tax treatment, but a charitable remainder trust cannot hold S stock. So you will lose your S deduction in a CRT, even though in a charity could hold the stock. Okay. Let's talk a little bit about planning in terms of illiquid assets, because this is a relatively recent development, maybe 15 years, which in the CRT world is recent. So you have an illiquid asset and you realize you have to use a NIM-CRUT or a NI-CRUT because you're not getting any cash flow until you sell it, and you don't know when you're going to sell it. So you put that asset in the trust and you don't get anything for the first year or two or three. But now you sell the property and you invest the proceeds in a balanced portfolio, and you're entitled to get 5%. But in today's investment world, you'll never get 5% because remember, you're limited to the lesser of the net income and 5%. And so in today's yields, you'll never get to 5%. So you're always going to get 2% or 2.5% or 3%, unless you skew the investments to a point where you get 5 or 6%. But in that case, you may be investing in inappropriate assets because there's too much risk, because today you can't get 5% ordinary income in most balanced portfolios. So someone looked at this problem and came up with a solution and said, well, I have a good idea. Why don't we use the NI or NIM-CRUT format until the asset sells? And then once the asset sells, the trust can flip, and that's the term that's used today, flip into a normal trust. And from that point on, you'll get the 5%. And the service said in a private letter ruling, okay, that's fine, and then reversed its position a couple of months later. And then finally, the regs were amended to say you can use a flip trust. And of course, as with most things that the service gives you, there are all sorts of draconian rules surrounding using a flip trust. But basically, a flip trust can be used if the flip event is set forth in the trust. The sale of the asset is typical, but it could be any event. It could be if the Dodgers win the World Series. When they win the World Series, this trust flips. Any event that is specified in the trust that can be objectively measured to occur or not to occur can be used. Again, it's typically the sale of the asset. The flip occurs the first day of the year following the event. And if you have a NIMCRUT, that's the one with the makeup, you can make up the deficiency while it wasn't a regular trust, but you have to do it before the first of the year following the year in which the flip occurred. Well, and remember, you have to make it up with accounting income. Well, if you've had a couple of years where you get no income and now you sell the asset, you're not going to have 3 years worth of accounting income of 15%, which is 5% a year for 3 years. So how do you get the makeup if you want the makeup? Well, somebody else thought of an ingenious thing, and that was, why don't we call capital gain income? Because if capital gain is accounting income, which it is not under the principal and income law, but if we call it income, then we can use it to make up the payments, because the asset will be sold in a given year, and we'll have till the end of the year before the flip starts to use the capital gain to give the grantor what the grantor didn't get in the past. The service said, okay, that works, even though there's a regulation that says a trust provision relating to income and principal that departs fundamentally from state law will not be respected. Well, there's not much that departs fundamentally from state law than this, because under the principal income, capital gain is principal, but the service is okay with it. Then some do-gooder taxpayer, and this is true, sent a letter to the IRS and said, you got this all wrong. Because remember, we're talking about accounting income here, not taxable income. Capital gain is taxable income. It is not accounting income, even if you say it's accounting income, because the only accounting income that occurs in a trust like this is the capital gain after contribution. Because for book purposes, this trust with $1 million asset has $1 million asset. And the trust's income is gain over $1 million. The service scratched its head after a while and said, you know, this person's right. Thank you very much. We're going to change the rules again. So now you can allocate post-contribution gain to income in the trust. And that post-contribution income, if it's sufficient, can pay the makeup for the years in which the client didn't get what the client was supposed to get. So that's how you use a flip trust, and most people use it for virtually all assets that are not liquid and that are going to be sold relatively quickly after the contribution. Okay, a couple of minor things before we go to lead trusts, which are not used as much, even though they probably should be. If your clients have created a joint trust, husband and wife create a joint charitable remainder trust, 5% to the spouses for life and 5% to the survivor, then to charity, and they get divorced, the service has been very liberal in allowing them to split that trust so that each trust is a single life trust. Charity gets the money early, but that's not usually the test of charitable remainder trust law. But in this case, the service has said, yes, you can create two single trust rules. If you're putting IRD, many pension plans are payable to CRTs because CRTs don't pay income tax, and the estate tax is lesser because you have a life interest and a charitable interest. So if you have a CRT for your child, for example, and you make your retirement benefit payable to your CRT, there is going to be an estate tax on the child's portion of the CRT. And under most circumstances, you would get a 691C deduction for the estate tax attributable against the income tax. But the service has said, no, the 691C goes to charity and it does the life beneficiary no good. That seems clearly wrong, but that's been the service's position for pretty much forever. Okay, let's move to lead trusts, which are the reverse of a remainder trust. In a lead trust, the payments are made to charity upfront, and typically after a number of years or a life, the assets pass to family members. And the forms for lead trusts are now part of the IRS lexicon. There are revenue procedures that set forth the forms. They're annotated, they're good, they're easy to use, and there are really no surprises. And in fact, the service has been generous in some respects. couple of respects. Well, first of all, the service has imported all of the charitable remainder trust provisions into the lead trust arena. There's really no reason for that. But again, you have the forms, you follow the form. People have thought forever whether you could use a variable annuity. Charitable lead annuity trusts are almost exclusively used because you don't want charity to get more than it has to get. So you want all growth inside the trust to pass to the family. If you use a unit trust, the life beneficiary, charity, and the remainder beneficiaries in effect share the appreciation. But if you use an annuity trust, the annuity is fixed and the appreciation falls to the back family. So almost everybody uses an annuity trust, even though it has one disadvantage. So can you use a variable annuity? Because again, if you can structure the annuity so the annuity payments in the beginning are less and greater in the future, then you have more assets to appreciate during the period of the annuity payment, and more assets will pass to the family. And that's known as a shark fin clap, because the annuity payments are structured to look like a shark fin, small at the beginning, gradually rising to the end. Wasn't clear whether you could do that, but the services said you can do that as long as on the date you create the trust, you can compute the annuity. And with computers today, you can compute the annuity. It's a present value of a series of unequal payments, but the payments are fixed. So you can backdate that and figure out what the present value is. Another thing that people used to do, because most clients who use lead trusts are egomaniac business people who think that their businesses are the best thing in the world, or their investment prowess is the best thing in the world. So the first question I used to get asked was, well, this trust is for 24 years because you told me that it has to be for 24 years for the present value of the charitable gift to equal 100%, so I pay no gift tax. Yes, that's correct, Mr. Jones. Well, I'm super good at investing. Suppose I hit a couple of home runs. Can I pay off the charity early and let this trust terminate early so my family gets the money before 24 years? And in the old days, we didn't really know whether you could or you couldn't. And many of us did do just that. We present valued, let's say after year 10, we present valued the remaining payments to year 24, and we paid off the charity early. The charity was thrilled, the client was thrilled, the service didn't know about it because it wasn't reported that way or didn't pay attention to it. And that happened from time to time. The service then came out with a ruling that says you can't do that. It then came out with a ruling that allowed someone to prepay the annuity when not present value, just added up the annuities and paid it out in gross. Obviously, the return was so big that they could afford to pay the annuity without discounting, and still the family would get the money early. The service has now said you can't commute, period. And the forms say you can't commute, period. On the other hand, the service subsequent to the forms has allowed one commutation in gross. So I'm not sure what the rule is, but most clients would like to be able to prepay. The answer should be no to the client. The next thing we used to do is we used to put our own ordering provisions in the trust. Just like in a remainder trust, the service wants the high income to come out first because the income tax will be paid by the individual. In a lead trust, you want the high income to come out first too, because charity doesn't pay income tax. That leaves low income assets in the trust, and that's a good thing. So services said no ordering. The charitable lead trust is a separate taxpayer. It's subject to subchapter J, just like any other taxpayer. And so you can't change the ordering. There are two types of lead trusts during lifetime, a non-grantor and a grantor. And there's a difference in how they are treated, as you might expect. And it's not checking a box. You have to make one or the other based on the provisions. So in a non-grantor trust, you don't get a deduction for the upfront gift to charity, but the income is not taxed as the income is earned by the trust. In a grantor trust, the grantor gets an income tax deduction upfront for the present value of the charitable stream of payments, but as those payments are made, the grantor pays tax on it. So you can pick your poison, whichever is more beneficial for the grantor. And the way you make a charitable lead trust a grantor trust is you give someone other than the grantor, normally, the power to substitute assets. Now, the statute says basically the grantor is the one who has to substitute assets, but that ship has sailed, and the service in many rulings, including the lead trust forms, say that if anybody has the power to substitute assets, it's a grantor trust as to the grantor. Because the lead interest in a lead trust is usually the grantor's private foundation, because you want to fund that foundation, if the grantor is an officer or director of that foundation, he can't exercise the power to substitute assets because it would be self-dealing. And so the power probably would be deemed to be illusory because he'd be subject to penalties if he did it. So in charitable lead trust, it's usually a third party who has the power to substitute assets, and the service says that works. By the way, if you are naming the client's private foundation as the recipient of the lead payments, that trust will be includable in the grantor's estate, and you will have accomplished nothing. So you need to provide in the foundation documents that the grantor can't deal with in any way, shape, or form the payments made from the charitable lead trust. They have to be segregated within the foundation, and people other than the grantor have to have the ability to invest the assets, distribute the assets, etc. It's somewhat of a fiction in most families because families work together to do everything. But on the face of it, the documents in the foundation need to make sure that the grantor has no power over the assets that are given to the foundation. One more, and then I think we'll take some questions because we're getting pretty close. So another technique for lead trust was the so-called Ghoul Trust, Ghoul like Halloween ghoul. And so I said that the lead trust can be for a term of years, which is typical, or it can be for the life of an individual. And so smart planners said, well, why don't I do it for the life of an individual? Because I will get the deduction for the present value of the term to charity for the life of an individual. And if I can find a young individual, I can in effect zero it out. The present value of the payments to charity will equal the life factor for a life of an individual. But I really don't want this trust to go on for the life of an individual because that person is going to be pretty young before I can zero out. So why don't I go down to Skid Row and find a 35-year-old who doesn't look so hot, give him a couple of bottles of wine, and say, can I use your name as the life beneficiary, life measuring life of this trust? And in a drunken stupor, he says, of course, my name is John Smith. Do you have a social security number? I have one. What is it? X. So I'm making you the life measurement of this trust. I'm expecting him to die pretty quickly because I picked him because he doesn't look so hot. I've plied him with liquor. I'm guessing he doesn't have a life expectancy. And lo and behold, he dies at age 40. My trust ends 5 years after it was created. It was supposed to end 40 years after it was created when he reached 75, but I bet that it wasn't going to happen. And my bet was, I won. Service said, you can't do that. You can't just go looking for some life expectancy that isn't so great. Now you can only use your spouse and ancestors as the life beneficiaries, or the life measuring lives, not the life beneficiary. And so the Ghoul Trust has sort of fallen into disuse. Dina, you want to take some questions? I don't want to go over my time.
Yeah, no, we are at time, but we just have a few questions, so I think we can get through them pretty quickly.
Okay.
The first question we have is, can you fund a charitable trust with property located outside of the United States? For example, in this instance, they're using Brazil as an example.
I don't see why not, although there may be some rules in Brazil that would prevent you from doing some, and there may be some tax consequences in Brazil. If Brazil doesn't recognize a charitable remainder trust that pays no tax when the property is sold, somebody may have to pay that tax. But the trust probably can be used for that. I'm not sure, to be honest.
Okay. The next question is a little bit of a three-parter, so I'll try to break it down for you. The question and comment is, I understand that the grantor can be the trustee of a CRT. However, if there is not publicly traded stock, there needs to be a qualified appraisal unless there is an independent trustee.
Correct.
First question is, Bitcoin is Bitcoin considered a publicly traded stock?
I don't believe so, no.
Question 2, do you believe that Bitcoins are proper investments of a CRT?
Probably not, because the Jeopardy investment rules of 4944 apply to charitable remainder trusts. That's not to say that 5% or 10% of some, wacky asset like Bitcoin could be in a charitable remainder trust. But if it's an asset that jeopardizes the charitable money, then you're going to have penalties. So the answer is yes, but very limited.
And then question 3 is, are there any special rules related to the grantor being the trustee and investing and managing Bitcoins or other non-publicly traded stock?
No, I don't think so. As long as you have an independent trustee who can value the assets each year for the 5% payout, if it's a CRUT, then no, there's probably none, except for the Jeopardy investment rules and the self-dealing rules. Obviously, the charitable remainder trust can't hold a significant interest in a closely held business. That would generate UBIT. It might be self-dealing depending on what the business does, whether the business is a pass-through and borrows money, makes loans to the grantor. I mean, it could be dangerous for the trustee to be for the grantor to be the trustee, but it's possible.
The next question is, since the assets are included in the grantor's estate, is there an estate tax or does the charitable deduction make it a wash?
It makes it a wash if the grantor or the grantor's spouse are the only beneficiaries of the trust. But if you create an inter vivos trust for your son, then the son's actuarial interest will be subject to estate tax. You'll get a charitable deduction for the remainder, but the trust cannot pay the estate tax on the son's interest. And there needs to be a provision in the trust obligating the grantor to pay the estate tax on the son's interest from some other source, or the son has to give up his interest in the trust. Typically, we put a provision in that says the grantor promises that the estate tax on the son's interest will be paid by the revocable trust or the grantor's estate. And that's enforceable by the trustee.
The next question we have is, do you generally give your clients the ability to change the charity? I understand this causes a CRT to be an incompleted gift.
It does cause it to be an incompleted gift, but there's really no harm in doing that. And I would say almost always do I give the grantor the power to change the charity. The one exception might be if this trust is being set up and you're getting something for it, like part of a naming opportunity, and the charity is going to be the trustee, then typically the charity will not want the grantor to have the power to change the charity because the grantor is getting something from the charity, a naming opportunity. But other than that, always, yes.
I think this is the last question. It's slightly a multi-part too, so let me kind of take it one at a time. Can a shark fin be used when the lead trust terminates on the death of the grantor?
I don't know the answer to that. I don't know. I would doubt it because when the grantor dies is an estimate. I mean, it's not a fixed amount. So you really never know what the annuities are going to be. Although the service may allow it because, again, we use the tables for a lot of things. So it may say as long as the annuities are run out to expectancy, maybe. I don't know the answer.
Well, the rest of the questions seem to assume that if you can use a shark fin, then does the 20% rule apply? But it sounds like that may not be the case.
Right.
Okay. I think that's it for all of our questions. Thank you, Paul, for staying on, and
okay.
And
thank you.
Thank you for your time, and we appreciate it. But and thank you everyone on the call for joining us and for sticking with us this entire time and listening to Paul's great presentation on charitable trusts. So have a great rest of your afternoon.
Thank you.
Thank you.